Suspended youth PS Lillian Omollo, NYS Director General Richard Ethan Ndumbai are free to be released after they meet their bail and bond conditions. Magistrate Lawrence Mugambi has this morning disallowed an application by the DPP seeking to have the Asset Recovery Unit verify their securities. He says it would be in violation of orders by the High Court granting the accused bail.
With due respect to the DPP, should this court uphold such a directive and proceed to suspend bail approval process until that particular condition is met as urged in his application, this court would be treading on very dangerous path of risking being cited for contempt that granted the accused person's bail and only require this court to facilitate that process through approval of sureties and ensuring that the conditions it made are met. To explicitly declare that the process is put on hold or suspended would be countermanding this express order of the High Court. It is tantamount to inviting the court to stomp its feet on red-hot charcoal, which invitation, with utmost humility, the DPP, the court must decline. It cannot suspend the implementation of the orders of the High Court.
All right, let me now bring in Zuya Walter, who wants to give us get us the sounds of the Defense Counsel in this particular matter, what they feel after that ruling by Magistrate Lawrence Mugambi. Zuya, what do you have for us? What are they saying? What are those lawyers or advocates saying about the way in which this case or this matter was ruled?
Good morning to you, Wahiga Mwaura, and indeed we are here at Milimani Law Court, where the Magistrate Court has declined to suspend the verification process of the NYS suspect, saying that if it does so, then the court will be cited for contempt of law, and saying that the application by the DPP will be like denying the freedom of the NYS suspect to be freed on bail. So in the application that was filed yesterday by the DPP, he had said that the IO failed to comply with the DPP directions to liaise with the ARA to have the sureties that are being presented to court be verified by the DCI. So I'm joined by lawyer Kihanga, who is going to maybe to give us more details of this ruling. Now, lawyer Kihanga is representing one of the accused persons in the NYS case. Maybe lawyer, yes, tell us more about this ruling. What does it mean for your clients?
Well, number one, it vindicates our client regarding the issue of surety. It is now, I believe now it's now settled law that once the court has already set out conditions for admission for bail, more particularly in the High Court and the lower court cannot now purport. The DPP cannot introduce an application to vary and amend the surety terms. Similarly also, the DPP have no role at all in terms of verification of surety. The role is specifically premised upon the DCI to work unfetteredly without interference from the DPP regarding that issue.
Okay, and the process of verification,
yes,
how far are you? So far we understand that there are 3 persons who have presented their papers before the court.
Yes.
So how far are you?
As far as 2 days ago, we had fully complied. What we are waiting for is a letter from NTSA, because we are using vehicles as surety, to confirm the genuineness of the logbook. That is all we are waiting for.
Maybe are you using title deeds?
No, we are not using title deeds. We are using our clients our friends who have graciously given us their vehicles as surety. So those are what we are using for, because vehicles are much faster than title deeds in terms of surety processing. Yes.
Okay, thank you. Now, Wahiga, as you've heard, now at around 2 p.m. we expect more lawyers together with relatives coming before the court to have the papers, the bond terms and sureties being verified by the court. So once as we know when the court or what the court will take any direction on this matter, of course we will let our audience know.